following program is classified G. It's suitable for all ages.
Tonight, we discuss the future of business transactions and the legal frameworks that govern them. How has the law kept with the evolution of enterprise? Where are the legal vacuums that allow big businesses to profit from customers living far away due to the incredible level of connectivity present in the status quo? Sri Lanka is shifting towards conducting most of its transactions online in both the public and private spheres of management. Is the law in our country ready for these advancements? Welcome to Law, Land and Liberty, where we are keeping with our promise to bring in a pertinent legal topic and break it down in the midst of an individual who is an expert in that field. And today we have indeed such an individual, and he's the General Counsel at the Information and Communication Technology Agency of Sri Lanka, Mr. Jayantha Fernando. Thank you so much, sir, for joining us. He's the founder head of legal at the Information and Communication Technology Agency. He's also part of the drafting committee when it comes to the Electronic Transactions Act, which has been the pioneering legislation when it comes to the field that we are going to talk about today. And in proceeding towards the discussion aspect of this, we are going to talk about something that has been within the public forum, something that has had a certain bit of a vacuum, I would say, a certain bit of a grey area. And we really have to shed some light on this, given the fact that the future of transactions, as we mentioned within the introduction as well, the future of transaction is going to be within the electronic and that specific community, that specific platform. And we really need to iron out those details. So in approaching this topic, we are going to talk about, as we usually do, we are going to break it down into 4 segments. Firstly, we are going to talk about the general framework, talk about the laws governing electronic transactions, particularly within Sri Lanka, then talk about the international standards as our second segment. Thirdly, the adoption of these standards by the agencies within Sri Lanka. And finally, we are going to talk about how legal action can take place when it comes to electronic transactions. All right, Mr. Jayantha Fernando, thank you so much for giving us this time. I know it's a busy schedule, and you're pretty much a professional in this field. You have been there for quite some time. You've seen the ins and outs and the direction that we should be heading. So maybe towards the end of the discussion, we will talk a bit about the vacuums, talk a bit about where we need to evolve. But firstly, now when it comes to electronic transactions, and something we have been mentioning within this channel as well, is that we need to move into that field, the automation aspect, to secure our data on those platforms and really have a more ironed out efficient system when it comes to transactions in general, and move into e-commerce, the commercial aspect of all of these things. It helps the entire country to move forward. So in those slides, Mr. Jayantha, where do you start to see this topic? When I pose the question of electronic transactions and the laws pertaining to electronic transactions in Sri Lanka, how does a person who's getting introduced to this field of law, where should they start?
Firstly, Danidu, thank you very much for inviting me for this discussion today. And I thank you and your team for the preparation of this segment. When we talk about the subject of electronic transactions, electronic commerce, and related issues, we should be mindful of a primary piece of legislation governing the subject, which is the Electronic Transactions Act. Number 19 of 2006, which provides the baseline legislative framework governing electronic commerce, electronic business, as well as electronic governmental related activities to enhance citizen services from government to citizens digitally. So if I may give a overview of the Electronic Transactions Act, there was a lot of work that went in from 1999 till about 2003, 2004 in formulating this framework through multiple set of recommendations. And the original pioneering step was taken by a law committee mooted by an organization called SINTEC, the Council for Information Technology, which was the legal predecessor to ICTA agency of Sri Lanka. And there were President's Counsel, eminent President's Counsel, members from the Attorney General, the then Attorney General himself, the chief legal drafts person, and the lady in charge of the legal drafts department herself took an active interest in pioneering the work behind what we see today. We were facilitators to the process. We gave input to the process, and we helped the drafting committee adopt appropriate international standards, which we will come to later.
Yeah.
But if you look at what has been enacted in 2006, it has several parts, but I just want to emphasize on the long title
Yes.
of the statute,
Yeah.
which simply states that that it is not a regulatory framework as such. It is a law to facilitate and recognize certain category of transactions, and the long title says the formation of contracts, the creation and exchange of data messages, electronic documents, electronic records, and communications in electronic form in Sri Lanka.
Okay.
That is the first part.
Just to interrupt you there, Mr. Jayantha, so this statute, this act can't stand alone, is something that you would mention. There are a lot of other subsidiaries that need to be attached with this when it comes to the subject of electronic transactions.
Well, how I would put it is that the enabling foundation comes from this legislation, and this I would say is the baseline legislation, but we have to bear in mind that there are certain classes of activity or instruments, legal instruments, to which this law would not apply.
Okay.
And those have been specified in section 23. So for example, a last will, a power of attorney, a deed of transfer for a property, immovable asset, which are heavily regulated through notarization and verification of the people who are involved in the transaction, which are specifically governed under the applicable law relating to those subjects. Then bills of exchange, for example, those have been excluded from the ambit of the Electronic Transactions Act. But pretty much everything else that we do in our present day, contractual frameworks are covered, because the long title and the objective clauses gives a broad, sets out the broad ambit that provides a strong foundation for the legal recognition of certain classes of instruments. So I mentioned the instruments called data messages, electronic documents, electronic records, and communications.
Yeah.
All those terminologies have been defined in section 26 in a broad way on certain international standard instruments that have come from UNCITRAL, which we will come to later, that would enable anything, including an SMS between each other,
Okay.
or email communication, or a web, or a technology-based technology-based AI tool being used for contractual arrangements being legally enabled and recognized through this act. So that is one part.
Okay.
Second part of the long title also states very clearly that this law sets the administrative law foundation to recognize electronic signature. So it says to provide for the appointment of a certification authority and licensing and authorization of certification service provider to give effect to an international instrument that Sri Lanka adopted in 2015.
Okay.
So we'll come to that later,
Yeah.
but broadly I think when we look at this act,
The long title gives
long title gives the overall ambit, and of course the objectives clause in section 2 states that this is a law to facilitate domestic and international electronic commerce, to encourage the use of reliable forms of electronic commerce, to facilitate electronic filing of applications, petition and answers in courts of law, And of course, we have new developments that have taken place with Supreme Court and Court of Appeal, appellate procedure rules being established in this COVID era that has has a overarching ambit.
Yeah.
And then it says thereafter to facilitate electronic filing of any form, application or any other document in any ministry, department, provincial council or local authority. So the ambit of the law is very clear. And in the chapter, in the sections thereafter, in chapter 2, we will find certain broad recognitions being given in this act to the digital equivalent of a writing, digital equivalent of a original instrument, or an original record. And then, of course, in section 7, there is a very clear set of principles giving legal recognition to electronic signatures.
Right.
Again, a provision that was amended substantially in 2017 through Act number 25 of 2017. But before I come to that, I just want to highlight a very clear message coming from section 3, which says, if I am to cite it, it says that no data message, electronic document, electronic record or other communication shall be denied legal recognition, effect, validity or enforceability on the ground that it is in electronic form. So what that says is simply, and that's a very important foundational principle here, if one were to use an electronic document as defined in this act, or an electronic record or a data message, and if there is an effort by a party to deny legal validity or enforceability for those classes of instruments, that argument will not hold water because of section 3 being clearly stating that all those classes of instruments should be given legal effect, validity and enforceability as well.
Multiple questions that come to my mind when I think with this explanation, Mr. Jayantha, but something I don't want to revisit again once we move ahead is one salient feature you mentioned was, I think, the definition aspect, the aspect that identifies, this is a data message, and that really trickles down to how evidence can be admissible within courts. What are the other features? Now, since we did reference the objective clauses within this chapter, when it comes to, like, when you speak to a regular layman, Sri Lankan, they would generally be a bit iffy when it comes to the subject of electronic transactions and whether the law has kept up with international standards, which we'll visit later on. But like whether the domestic law has been updated to that level. You reference within what you were saying, there were amendments made in 2017, if I'm not mistaken. What are those salient features that you would point to saying, okay, look, these are key developments. These are key areas where you're protected. These are key areas where your data can be actually admissible within courts. Where would you point to within this act, within this framework, before we go into the next segment, are the most important features?
Yeah. So if you look at, for example, the objectives clause itself was amended in 2017 to bring more clarity. Okay. So for example, in the context of digital government activity, there was a bit of a doubt whether section 8 of this act, which provides for the underlying principle that anything done manually in manual form in government, including issuing of receipts, carrying out procurement transactions, including issuing of licenses, filing of records, maintaining records in government. There was a doubt as to whether that could be done in digital form. Yeah. Section 8 clarifies that, but because of the language formulation issues, there was an attempt in 2017 through Act number 25 to bring clarity to that. And then, of course, in the objective section, what was done together with the long title was to amend certain elements here to introduce the standards coming from the UN Electronic Communications Convention that Sri Lanka ratified on the 7th of July 2015 after a gap analysis that was done through the period 2013, 14 and 15. In 2014, Sri Lanka hosted a very significant event, international event, with experts from the United Nations Trade Law Commission. They came in here, and there was a multiplicity of legal professionals from the Aegis Department, Legal Draftsman's Department, Central Bank, and other regulatory entities participating in that endeavor, which I think was in September 2014. And then private sector counsel took part in various panels, and we came to consensus on key areas we need to bring clarity. So if I'm to articulate that more clearly, there was an issue about the technology neutrality that this law would provide in terms of giving legal recognition to electronic signatures.
What would you mean by technology neutrality?
In any legal framework, if we specify type of technology for the use of electronic signatures, right, every time the technology changes, the law will have to change.
Yes.
So what the international standards bring into the legislation is to maintain broad language so that any technology that comes in can adapt itself, or we can adapt the language to meet the growing demands emanating from technology evolution. So Section 7 that was brought in.
That is the kind of language that is used in the Act, yeah.
Exactly. So Section 7 again was validated by both international and local experts.
Okay.
And we brought in broad language with regard to how electronic signatures can give legal recognition. And that was one of the key changes done through the amending act. But what is important is that in giving comfort to society, I can understand the genuine concerns, because average people out there will still question whether non-human intervention-based activity done via digital means are legally valid, and whether records maintained digitally are legally valid. Whether, for example, you go to the passport office or some other governmental entities, they will give you original records back.
Yeah.
But what is important is that it has come to stay right now, even in Sri Lanka, that many government entities have adopted this in such a way that our original records are given back to us because they scanned and archived and maintained those original documents in digital form, making use of Section 4, 5 and other areas in this statute that gives legal recognition to electronic equivalents of original. Right. So that's a foundational kind of a framework that I just want to make you aware, so that people will be mindful
that these are available.
That the law gives comfort
to
that kind of level of recognition, so that people will know there are adequate legal provisions to facilitate and enable all kinds of digital activities except those which are excluded under Section 23.
All right. Ms. Jayantha, quite a few things I need to clarify with you, but we have to go in for a short commercial break. Stay with us on Law, Line and Liberty.
Hi, I'm Ayushmanta Vikramasinghe. I'm a freight forwarding executive. So my question is, what are the international standards that should be upheld when considering the law on electronic transactions?
Welcome back to Law, Line and Liberty. We are in conversation with Mr. Jayantha Fernando. He's the General Counsel at ICTA in Sri Lanka. Ms. Jayantha, a very important first segment that we passed. And now this segment we want to primarily separate to international standards and to really touch on this UNCTRAL model law on electronic transactions and how that has really impacted our country. But before that, Mr. Jayantha, I want to clarify this question now. People area that most people wouldn't be aware of now, since in this day and age we tend to do transactions online with multiple entities, multilateral companies which may be based far away from our country, but still there's a monetary transaction that happens, and that monetary transaction should then equate to some form of accountability. Are those areas also touched within this? Are there any standards given to those companies that conduct enterprise commercial activities within Sri Lanka or even any other country? Actually, within Sri Lanka, is that touched from this act, or is there some standard that those companies should follow?
Yeah, good question, and maybe I can clarify the distinction between the contract and the other aspects of consumer protection. Yeah. So many of these international players which afford services to Sri Lanka, which are to our benefit, goods or services, whatever category, do it through app-based solutions, and it's available at our fingertips, and we can get those services very easily to our home. So what is interesting is when we download an app which provides that service through an international or a local entity, we may necessarily be subjecting ourselves to terms and conditions that come with it. Very often we just skip it. We just say I agree without reading the fine line, and often these are web-based arrangements, and by clicking I agree, we have signified acceptance. And I would think in some cases, if they apply Sri Lankan law, we can certainly invoke the provision of the Electronic Transactions Act and bring that contractual element within the category of electronic contracts in chapter 3 of this Electronic Transactions Act. Okay. But if it is a foreign law, that is the applicable law, there would certainly be an issue as to the forum or the jurisdiction, or which court would have the jurisdiction to hear and determine an issue relating to that particular contractual matter. Having said that, what I want to emphasize is that when it comes to the quality of goods or the quality of services, whether the service made available through the digital platform is subject to local taxation, that aspect would not be covered under the Electronic Transactions Act. So for the taxation aspect, the local laws governing taxation would be applicable, and there are international norms that emanate from international standards coming from WTO, and the latest being from the OECD community. They have certain fundamental principles. So the policymakers in this country would have to look at those for guidance when they amend the tax law to rope such digital-based activity into the tax net. Similarly, when it comes to issues of the quality of service or warranties relating to the products that were perhaps sold to us, there would be other laws coming in, the sale of goods ordinance, and of course primarily the consumer protection laws. Now, consumer protection aspects have not been dealt with under the Electronic Transactions Act because the international standards coming into the subject of electronic transactions left it to the consumer protection authorities of a particular jurisdiction to carve out the set of principles under which they would like to govern the products and services supplied to citizens in their country. So I would think that while we are quite advanced on the electronic transactions legal regime, one gap I would like to note in relation to digital commerce, digital transactions, is in relation to consumer protection. and taxation issues where a lot of policy interventions are yet to happen.
Okay. Ms. Jayantha, I don't want to take much of your time. Since we did touch on the aspect of international standards, where do we start in discussing that? Because the UNCTRA model of electronic transactions is something that we followed. You mentioned that in the documentation stages, we are part of it. We're one of the initial countries to really recognize this as well. So is there a standard that we should follow uniformly across the world, or how does that really affect the country?
Yeah, that's another fantastic question. In fact, one of my favorites that many law students also ask me. Actually, the original foundational principles for electronic transactions, electronic commerce, generally came from the UNCTRA model law on electronic commerce, which actually predated the widespread use of the global internet. So this was in the era of something called electronic data interchange, where there were closed networks. One example is the banking, international banking fund transfer. You have something called SWIFT.
Okay.
That's a EDI model, and there were several ones like that for shipping, logistics, and many other areas of activity. But with the growth of the internet, and internet being used for cross-border trade, and with internet being used for the benefit of people, where those who provide a service could make available products and services to citizens in multiple countries globally, it became a multi-jurisdictional issue. So what happened was that the original UNCTRA model law came from a working group on electronic commerce at the United Nations Commission on International Trade Law, founded many decades ago. So the model law of 1996 was a set of broad principles that said, okay, electronic equivalent of a writing can happen if certain minimum standards were met. Electronic equivalent of a signature can happen if these standards were met. And because it was only a model law, countries started adopting higher standards and lower standards. And there was no harmonization happening at an international level. As a result, cross-border electronic trade became a problem because of the varying standards countries were having. And this became a barrier to the growth of global electronic commerce and electronic trade. And what happened in around 2001-2002 was that the UN General Assembly gave a mandate to UNCTRA, which is the United Nations Commission on International Trade Law, Working Group 4, the Working Group on Electronic Commerce, to set a new set of rules that would be binding on states once those states agreed to adhere to it. So it became a treaty or a convention, and that convention became known as the United Nations Convention on the Use of Electronic Communications in International Contracts. It's a long name, but it's a very short instrument. And that became known as the International Gold Standard on Electronic Commerce, and now known as the UN Electronic Communications Convention for simplicity's sake.
Okay.
So Sri Lanka had the good fortune to be part of the drafting committee that negotiated this instrument during a very short span of about 3 to 4 years. It was chaired by the then head of the civil division of the Attorney General's Chamber in Singapore, Senior Counsel Jeffrey Chang, whose name I need to mention specifically because he set the guiding rules so that common law countries globally, civil law countries could come to a happy marriage in coming to some consensus that set the rules in this instrument. And because Sri Lanka was part of this, and the then legal drafts person herself took part in the deliberations, we were able to draw on certain fundamentals that came through. Actually, it was Mrs. Thiris Perera, President's Counsel, who helped to formulate the Electronic Transactions Act at that time. And with her guidance, we were able to model certain foundational principles in the statute based on that international standard, so that this law would have some kind of international recognition. So we became the first country in South Asia to adopt this standard and amend the Electronic Transactions Act in 2017. The then Ministry of Digital Infrastructure played a pioneering role in doing it, and we at ICTA and the Legal Process Department collaboratively with the Attorney General's Department worked together with some experts to do the gap analysis that I mentioned, and then we helped to formulate the foundational principles, and the act was suitably amended. And with that, Sri Lanka formally adopted this international standard, being the first in South Asia to do so, and the second country in Asia after Singapore. Now, this international standard has had an international impact, if I may conclude by saying that China is now adopting this standard, and Australia has adopted this. And the next in line are Philippines, South Korea, and Japan. Already they have signed the instruments, and they are doing the domestic reforms in those countries to ensure compliance with this standard, so that cross-border electronic commerce and trade can be given legal validity.
Before we go in for a break, Ms. Jayantha, very shortly, if you could address this, and we'll take more time on the other segment. The standards that have been established, where are we in the ratification process of it? Are we a country that you mentioned, since we were the first in South Asia to actually comply, and we were part of the initial committees that were drafting this? Do we have a long way to go in those regards, or how would you?
When the instrument was opened for signature in July 2006, China, Singapore, and Sri Lanka were the first in line from Asian region to signify our commitment to join this treaty. So that was in July 2006. Since then, a lot of things happened, and the gap analysis was done between 2013 to 2015. In July 2015, Sri Lanka formally deposited the instrument of ratification. Our Minister of Foreign Affairs Legal Division played a lead pioneering role in preparing the paperwork to ratify the instrument on the 7th of July 2015. And this came into effect on the 1st of February 2016 in Sri Lanka. So we have already adopted it, and Sri Lanka is a state party to this convention. So what significance it has is that it clears the gray areas in terms of cross-border electronic commerce and trade, and maybe later on I will explain to you some of the about one or two very key features that actually makes this law very unique compared to other electronic transactions laws in across the region.
I think that would also be a very interesting area. We've just covered, I think, quite a lot of content. Mrs. Jayantha will go in for a short break and be back on exactly where else in terms of admission of evidence and those areas.
Hi, my name is Ryan and I am a law student. My question is, how are the globally recognized standards adopted within the domestic organizations within Sri Lanka? when it comes to electronic transactions?
Welcome back to Law, Land and Liberty. We are in our third segment. We're going to touch on the adoption of the standards that we mentioned within the second segment, actually. And Ms. Jayantha, a lot of clarifications that you made within our first two segments where we spent some time on. Now, please continue from where we ended. And something I want to clarify is if you could really push on the practicality of these standards, because there are multiple institutions. ICTA is one, the customs, and these other institutions that are involved with electronic transactions on a daily basis. How have these standards really trickled down to those administrative levels? How does this function within Sri Lanka?
Yeah, so that actually generally gets coupled with the digital strategies that are adopted from time to time. So the digital strategy adopted by ICTA from 2020 onwards, there has been a very clear direction and path taken in terms of supporting digital government initiatives and digital economy and digital services initiatives as well. Always there is room for improvement, we all know that. But the digital transformation process is a long journey. Transformation and changing people's mindset is not something easy to achieve.
True.
So it is a stairs game. Mainly you have to stay in the subject for some time, handhold stakeholders and support them to build confidence in the ecosystem for digital adoption, which is happening. Over the last decade or so, we saw Sri Lanka improving in our standards relating to digital government, digital commerce, digital economy ecosystem. And most notably in recent times, we saw in the digital banking arena, the central bank together with the Ministry of Technology and ICTA work together collaboratively to create more certainty on digital adoption. One of the most recent innovations is what happened at the Colombo Stock Exchange through a digitization initiative pioneered jointly by the Securities and Exchange Commission and Colombo Stock Exchange together with joint committees from both sides, working together with stakeholders to create greater certainty for participants to take part digitally. So one innovation that came out of that was to map some of the contractual cycles in the digital onboarding system at Colombo Stock Exchange to the Electronic Transactions Act. And now at the press of a button, you can download the Colombo Stock Exchange digital app and become a participant in the ecosystem. And my colleagues have informed me that the latest statistics indicate that over 60,000 people have downloaded the app and digitally onboarded themselves to the CDS account and taking part actively. And maybe more work needs to be done in terms of awareness of the market conditions so that people can take part in that endeavor. Now, that is an example of the adoption of the electronic transactions law in recent times in that sector, in the capital market arena.
Yeah.
So the onboarding tool has got terms and conditions. It is mapped to a verification of the identity meeting the KYC requirements of the central bank, and that tool that connects the verification of the identity with the registration of persons department was developed by the ICTA technology team.
Okay.
And it is now working effectively, servicing telcos, servicing banks in terms of how they verify a customer in terms of the authenticity and validity of the identity card. Now, that was done and made possible through the Electronic Transactions Act through a regulation made under this act and promulgated as the Electronic Transactions E-Registration of Persons Regulation number 1 of 2019, gazetted on the 21st of March 2019. That regulation was really put into effect last year, and the new onboarding, digital onboarding platform was launched in September 2020, and it has had a huge impact in terms of adoption.
Okay.
And another example that happened in recent times was the Sri Lanka Customs permitting digital submission of customs declarations. And for that purpose, I was informed when I got the latest statistics from the electronic signature service provider that is licensed and authorized under this act that operates within the framework of central bank, which is known as Lanka Clear. According to the statistics, over 1,000 corporate entities have been issued, over 500 organizations have been issued digital certificates to enable them to submit customs declarations online. So these are positive developments of how the Electronic Transactions Act is being used on a day-to-day basis. Okay. And the latest statistics indicate that although there is a bit of reluctance on the part of people to use electronic signatures, the local domestic certificate service provider has issued over 600,000 certificates to a large number of players, including individuals in corporate entities.
Okay.
So with that kind of adoption, I think it is important for stakeholders to understand that we are on a moving bus, so to say, in the digital transformation journey. And if you are not part of it, you will miss the bus.
You'll miss the bus. A very good position. Take a very short break. Ms. Jayantha, a few other things I need to clarify with you. We'll take a very short break. You're with Law, Line and Liberty. Stay with us.
Fernando, and I am a science undergraduate. My question is, how can court proceedings be taken when it comes to disputes pertaining to electronic transactions?
Welcome back to Law, Land and Liberty. We are in conversation with Ms. Jayantha Fernando. Ms. Jayantha, three very important segments that we just passed, and in our last segment, I wanted to keep it a little general and get your take on things that we miss out on, and primarily focus a bit on how this evidence submission when it comes to court proceedings, the entire aspect of that, and how whether it's a criminal offence, whether it's a civil offence. Those are the questions that laymen would have when it comes to this subject. How do you think you approach that entire aspect? Are we clear there? Is it easy to admit evidence when it comes to electronic evidence, or when it comes to these kind of transactions? Is that an area that we need to really develop on?
That's a very interesting question, Danidu. I would say that on the subject of electronic evidence, we can spend hours and hours splitting hairs and debating on the subject. But there are areas of clarity and there are areas of doubt. We have to be clear about it. On the areas of clarity, I just want to emphasize that the Electronic Transactions Act number 19 of 2006 in part 5 or chapter 5 has introduced a set of rules governing admissibility of electronic evidence based on certain standards that evolved in several common law countries, most notably the evolution coming from the Civil Evidence Act of UK in 1995. What is interesting is that the parameters under which information contained in data messages, electronic records, electronic documents, etc., touching any factual issue or relevant fact, and compile, received or obtained during the course of any business, trade or profession or other regularly conducted activity is deemed to be admissible in a court of law pursuant to Section 21 of the Electronic Transactions Act. Okay. What is interesting is that this act contains what we call a rebuttable presumption, which basically imposes a burden on the party that tries to shut out the evidence to say why the information contained in a data message or electronic record should not be admitted. So that is a very novel regime that was brought in, keeping in mind the sacrosanct principles of the rule against hearsay, which has been a sacred principle in our evidence ordinance, maintained from time immemorial. And notwithstanding that, the Electronic Transactions Act of 2006 contains a greater flexibility in terms of admissibility. However, the decisions of court that have emanated from on this subject has been quite clear with regard to its applicability. So we do not have too many cases that have ended up in the Court of Appeal and the Supreme Court, which would give a dicta that has binding legal validity. However, there are dicta from the Civil Appellate High Court, for example. So one case that came up around 2013 or 14, I believe, was one matter relating to admissibility of electronic evidence in a divorce proceeding, okay, where the court held that the Electronic Transactions Act is, and that's the Civil Appellate High Court held that the Electronic Transactions Act is for trade, business, commerce related matters. Yeah. Using, the court even used the contents of the Hansard with related to the parliamentary debate that went to the adoption of this act, okay, and concluded that it is for trade, business, commerce related activity, and therefore that matters relating to divorce coming from the General Manager's Ordinance and personal related matters may be excluded. So there was a recent committee of the Ministry of Justice that made a recommendation to bring more clarity to this issue. So those are being considered. So what I want to emphasize is that as and when courts give their pronouncements, there is a need to review the status of this law and its applicability. And what is important is that change is a necessary reality we had to live with, and such appropriate changes that come through expert committees may have to be looked at positively to see the scope and ambit of this act. Now, in terms of your question about admissibility in relation to criminal matters, it is a well-known principle, quite well established in our legal system, that we have a dual regime. One regime coming from the Electronic Transactions Act, and of course we have the Evidence Special Provisions Act number 14 of 1995, yeah, which talks about admissibility of audiovisual recordings and information contained in statements produced by computers in civil and criminal proceedings. So, of course, the Evidence Special Provisions Act has certain inherent weaknesses because of the rigid set of rules that it requires parties to adhere to. For example, giving notice and giving the other party access, yeah, to the system from which information was generated to see whether the system was working properly. Now, in the day and age of the internet, where parties are in multiple jurisdictions. How is one party going to inspect a system in another country? So there are inherent issues with the Evidence Special Provisions Act number 14 of 1995, and it may be prudent to review the overall impact and make suitable amendments to that piece of legislation.
In the future, Mr. Jayantha, quite a few things that we have left to talk about, but unfortunately we don't have the time to do so. This is generally the case when an individual such as yourself comes to give us a certain amount of resource pertaining to this subject. But thank you so much. We covered a lot of content when it comes to this topic, and hopefully we'll see you again on this program. Mr. Jayantha Fernando, the General Counsel at the Information and Communication Technology Agency of Sri Lanka. He's the founder head of legal at ICTA, and he was part of the pioneering committee who drafted the Electronic Transactions Bill, which in turn turned into an act and is the primary legislature that we deal with. Thank you so much, sir, for joining us today.
Thank you. Thank you very much.
All right. The 21st century has opened windows to quite a few areas of technology that have in turn made day-to-day life more efficient. Electronic transactions and in extension e-commerce can be considered as one of the most important developments that would most certainly change the way enterprise is conducted. A serious area of concern that the law should keep up with. Newton Lee, a renowned computer scientist, author and administrator in the field of technology commercialization, once said, "As the world is increasingly interconnected, everyone shares the responsibility of securing cyberspace." Given that the future of operations relies on cyberspace, we must make an effort to understand our responsibilities as well. That is all from us here at Law, Land and Liberty. If you had missed today's program, you can watch the entire episode on our YouTube channel, youtube.com/Derana English. Join us again next week as we break down a contemporary legal topic. I'm Danidru Tanavasa. Have a great night.